The following program contains language about drug laws. Viewer discretion is
It's a question often raised in today's heated discussion about the advocacy of drug policy. Do regulations outlawing certain drugs actually work? Drug laws have been a controversial topic among our society, and for good reason not to mention. The use of legal drugs, such as alcohol and tobacco, far outpaces the use of illegal drugs. It is clear then that laws discouraging drug use do have an effect in keeping rates relatively low compared to the rates for other drugs that are legal, and therefore more available. However, over recent years, the legalization of drugs has allowed for more people who aren't of legal age to have access to them. This is, to nobody's surprise. However, it's concerning how many adolescents are gaining access to drugs illegally. Over the course of Canada's history, laws concerning drugs have changed quite a bit, and therefore it's valid to have adequate knowledge about. I'll be going over the majority of its history, concerning how it affected people back when, how it's affecting people currently, and how it could potentially affect people in the future. European colonizers from Britain and France introduced alcohol to the Native Americans. Alcohol was exchanged for valuables such as furs, but the introduction caused devastating impacts on the native communities. There was growing opposition to the consumption of alcohol. The white moral reformers saw alcohol as a force of corruption, and thus, the prohibition of alcohol became their goal. From the 1700s to 1800s, psychoactive substances were legal in Canada, and numerous were taken for medical purposes. In India, China, and the Middle East, people consumed opium for pain operations, as did Europeans. Opium was brought to North America by European settlers and vended as drugs that were completely legal, taken orally or in teas and panacea. Coca, a substance which cocaine is deduced from, was grown in South America thousands of times and came to Europe and Canada after South America was settled. In the late 1800s, products like wine and cough drops containing the goad became commonplace. People suffering from a range of conditions, including depression, which wasn't honored as a condition, and wakefulness, also consumed cannabis for relief. These were considered to be specialized drugs. In the 19th century, opinions about these substances changed due to Protestantism, a Christian movement, which emphasized moral purity and sobriety. The substances that people were taking upset the medical community. These drugs were brought to the West by foreigners, thus posing a threat to the morality of the white middle class. Britain and China fought two opium wars that ended with British victory, securing their opium trade. And the second, with France fighting alongside Britain, was in 1856. Demand was strong in the West. When China tried to end trade, conflict and war broke out, especially because of the harmful effects of drug use, especially on outsiders, as they were seen as enemy warriors. Vancouver is the birthplace of prohibition in Canada, largely due to the large amount of discrimination and racism prevalent there. Since it contains a lot of widespread anti-Indigenous racism, anyone branded as Indian was prohibited from purchasing alcohol. Chinese Canadians primarily smoked opium for pain relief, but this caused a lot of riots. However, in 1907, the riots led to the creation of the China Anti-Opium Federation. They believed that opium is a social evil. This paved the way for the formal criminalization of drug use across Canada. This in turn led to the Opium Act of 1908, which was later updated to become the Opium and Drugs Act in 1911. The new act added other drugs to the list of prohibited substances, including cocaine and morphine. After World War I, the Opium and Narcotics Act was passed. Mackenzie King then became Prime Minister, and drug regulation began to be centralized and consolidated under the Narcotics Division, a newly created division of government. At this point, the RCMP will assume the role of punitive drug law enforcement, which is tied to a system that opposes drug retention programs in favor of abstinence and imprisonment. The prohibition of drugs in Canada is highlighted by figures who have played a major role in shaping policies that continue to harm communities, more than those subject to racial discrimination. Emily Murphy was a noble figure, a former judge, and an ardent moral reformer. who even published a series of articles that would later be compiled into books. She later played a role in banning marijuana. In the late 1920s, the police increased surveillance of pharmacies and anyone who used drugs. In 1938, 11 drug groups were criminalized. 75% of drug convictions were for possession, and almost 3/4 of those resulted in a prison sentence. Since opium was prohibited, many people switched to injecting heroin and morphine. People who used drugs were seen as pathological in addition to criminals. A stereotype began, calling anyone who used drugs criminal drug addicts. Although heroin was rarely legally prescribed, it was still available. However, in 1955, Canada stopped issuing permits for it following the recommendation given by the World Health Organization. According to the official drug policy history of Canada, lysergic acid diethylamide, commonly known as LSD, was legal in Canada in the 1950s. Reason being, it had many therapeutic qualities and was experimented on for the treatment of schizophrenia and alcoholism. The government deemed it necessary since it kept patients sane. It was a time of political and social change in Canada. With many activists concerned with the government ruled by John Diepen, the counterculture movement was more open-minded to alternative views about sex, race, and of course, the use of drugs. Due to this, the use of illegal drugs skyrocketed as society coalesced around a desire for change. Drug laws became more harsh. The Narcotic Control Act legalized discrimination against people who use drugs. In 1961, Canada signed the Single Convention on Narcotic Drugs, an international agreement that weakened domestic control over drug policy. It reaffirmed and strengthened a criminal justice approach to substance use. Cannabis soon revealed a racist double standard in the law. White university students preferred cannabis and would easily get away with using it. The drug policy discriminated against mainly black and Chinese men, and by 1972, the arrest for cannabis possession dramatically increased. Approaching the end of the 1970s, the activists' numbers were waning, partly due to the government's attacks on labor and flagging economy. Even so, the advocacy to end the drug war continued into the next decade. In 1987, Canadian Prime Minister Brian Mulroney introduced Canada's first 5-year national drug strategy. Canada then signed the Convention Against Illicit Trafficking in Narcotics and Psychotropic Substances in 1988. In 1997, the Controlled Drugs and Substances Act replaced the Narcotic Control Act in Canada. A few activists co-founded Canada's first drug user union, VONDU, which stands for Vancouver Network of Drug Users. Thanks to the efforts of VONDU, the Vancouver-Richmond Health Board declared a public health emergency. After citywide consultation, in 2001, the Drug Policy Coordinator authored a seminal report. A 4-pillar approach to drug problems accepted drug harm reductions along with treatments. The 4 pillars was adopted as an official policy by the City of Vancouver and would then proceed to inspire drug policies all across Canada. In 2006, Stephen Harper introduced their national anti-drug strategy. It opposed harm reduction in favor of law enforcement, using long-held stereotypes and myths about substance use to advance their anti-drug agenda. They tried to shut down the injection sites that were helping out people in danger. This created opposition between people that use substances and the government. In 2011, the Supreme Court of Canada ruled that closing down injection sites would violate the people's charter rights. Soon after, a heroin-assisted treatment trial was conducted. As the study concluded, there was a realization that people really did benefit from these substances. As of September 2017, Vancouver's Crosstown Clinic has been providing North America's only heroin-assisted treatment program. Currently, bold initiatives and activism are writing the next chapter of drug policy in Canada. Especially with access to drugs being on an all-time high, this is an issue of concern for parents and their children all across Canada. Opinions on substance use have changed over the years. These opinions are very important because they change the way substances are controlled today. Whether they are morally right or not doesn't matter in the face of society. However, we need to look at how they affect people. The argument has been that people who are reliant on substances can't just have them taken away. They'll, at the minimum, need some sort of replacement or even just some help to reduce the use. This always comes with disagreements from opposing parties. Just like how the Stephen Harper government back in 2006 wanted to shut down all injection sites because they found them to be unreasonable. Calling it unreasonable doesn't make any sense, because the government itself hasn't been faced with problems of substance use. The government's decision needed to go through a form of legal realism, since they don't know what they're talking about. Hypotheses must be tested against observations of the world before coming to a conclusion in this case. Perhaps instead of the government deciding on whether any form of drug regulation should be allowed, people who have enough experience, who can make rational decisions, and who can support themselves should be making these drug regulations. This was recommended by many activists of substance use, and also by people who didn't support it. This would be a test similar to the already existing reasonable person standard implemented in Canadian law. A majority of people, while thinking about substance use, view it as a bad thing, and in turn believe that people who use them are bad. Just like the government, the majority of people don't rely on substances, so they wouldn't know what it's like. They don't know what's actually right or wrong because they haven't had an experience with it. That's not to say that substances are necessarily good for you. Only under certain circumstances should you be using them. However, people still get discriminated against and unfairly judged, even in the right situations. However, none of these would be implemented unless you have a person of power. Mackenzie King was one of the first people in power to make a decision on manufacturing drugs. He declared that opium should be non-manufacturable, and for good reason. Opioids were too powerful and far too addictive for human absorption, thus it was banned from further production. John Diepen, on the other hand, had very strong views about having drugs prohibited for public use. This, of course, caused backlash on the government he ruled, which brought society into the counterculture movement. Brian Mulroney announced the first 5-year national drug strategy, which helped in reducing illegal substance use. Notice how all these people in power were never influenced by drugs, yet were making decisions about them. While the majority of decisions were for the greater good, it is strange how a lot of people accepted decisions from the government, who imposed these decisions onto others without even knowing the consequences. We can go over a case, R.V. Malmo Levine in 2003. A brief overview states that 2 RCMP officers approached C and smelt a strong odor of marijuana. C claimed that he smoked a half-a-gram joint. He possessed the joint for the sole purpose of his own use. The former Narcotic Control Act states in Section 3.1 that unless authorized, no person shall have a narcotic in his possession. The penalty for this is a maximum fine of $1,000, or up to 6 months of imprisonment, or both for a subsequent offense. C was convicted of simple possession, in which the Court of Appeal, in a majority decision, upheld the conviction. M, who describes himself as a marijuana freedom activist, helps operate an organization known as the Harm Reduction Club. The organization recognizes some potential harm associated with the use of marijuana and seeks to reduce it. In December 1996, police seized over 300 grams of marijuana from the organization. M was charged with possession for the purpose of trafficking under Section 4.2 of the former Narcotic Control Act. All sides agreed that marijuana is a psychoactive drug, which causes alteration of mental function. Since that is the purpose for why subjects use it, it raises the question of whether it should be allowed. There are concurrent findings that harm is neither insignificant nor trivial. The trial judges in C's case estimated that there are roughly 50,000 chronic users of marijuana. Marijuana poses particular risk to pregnant women and schizophrenics. Protection of these certain groups and others that are vulnerable are definitely a priority as stated by the court. Also, it is the Parliament's responsibility to decriminalize any aspect of the marijuana laws that are no longer constitutional or is considered to be good public policy. A psychoactive drug that causes alterations in mental functions raises issues of public health and safety. Usage of marijuana is therefore worth enough for the exercise of the criminal law power. For a law to be classified as criminal law, it must have a valid criminal law purpose backed by a prohibition and a penalty. Since you can be imprisoned for possession of marijuana, it is sufficient to trigger scrutiny under Section 7 of the Charter. However, M's goal to design a lifestyle around the recreational use of marijuana is not protected by the Charter. There's also a punishment issue involved. If in no situation can someone, in this case M, be saved, what punishment should be let out? It could be approached in light of Section 12 of the Charter. Having no minimum sentence while there exists sentencing principles means that just the availability of an imprisonment of a marijuana charge may not violate the principle of gross disproportionality. A particular form of penalty that violates Section 12 of the Charter may call for constitutional remedy in relation to the penalty. The criminalization of the conduct may still be constitutionally punishable by an alternative form of penalty. M's equality claim must fail, since prohibiting the possession of marijuana for the purpose of trafficking does not infringe Section 15(1) of the Charter. Also, a taste for marijuana does not qualify as an analogous ground for Section 15 to protect against. Although the trial judge was clearly unimpressed by what M wished to establish, there was permit for M to put forward a full record in the event of an appeal. The result was that the trial judge's error did not prejudice M. The impugned provisions fall under the criminal law head of power. Parliament relies on the protection of health as its legitimate public purpose. It has to demonstrate the injurious or undesirable effect from which it seeks to safeguard the public. The Parliament is allowed to qualify something of little or no threat of harm as a public evil. The harm associated with marijuana poses little to the user, mainly health risks. However, the harms range from almost non-existent for low occasional users of marijuana to very significant for chronic users. Harm to oneself does not satisfy the requirement whenever the state resorts to imprisonment. There has to be a minimum harm to others. Inclusion of cannabis infringes the right to liberty without the regard for the principles of fundamental justice. It's doubtful that it's appropriate to classify marijuana consumption as a legitimate use of the criminal law in the light of the Charter, since the moderate use of marijuana is on the whole harmless. The availability of more tailored methods makes it useless for the choice of bringing out criminal law for controlling conduct that causes little to no harm. By allowing this, it leaves Canadian society's standard of justice at low reputability. The harm of prohibiting marijuana usage far outweighs the benefits. Now, since the Crown did not attempt to justify the prohibition under Section 1 of the Charter, it has not satisfied its burden. I agree with the decision made. If there is little to no harm, why should the accused be criminally charged? Moderate usage of marijuana causes little to no harm in general. It does not affect anyone but the person using it. If the user has marijuana taken away from them, their rights could be infringed, and they could do irrational things because of cravings. Therefore, the prohibition does not outweigh the usage. Natural law could state that taking away a naturally made substance that causes relief and bliss should be allowed to be used despite the low harm it might cause. Of course, chronic use of marijuana is bad for you, but that is not the case for M. However, natural law could also state that even if a naturally made substance can make you feel good, if it causes damage to one's physical state, it should not be used. Since there is a possibility that the user will continuously use said substance, it'll cause long-term damage. Despite this, I still believe that the decision made was more correct. Drug usage is dangerous. It can harm your brain and body when taken frequently, sometimes permanently. More importantly, it can hurt the people around you, including friends, family, and unborn children. Drug use can also lead to addiction, which is the main reason for harm. There's a drug overdose crisis in Canada. It is by far the worst public health crisis besides COVID-19 that this country has faced since the Spanish flu back in 1918. Since 2016, over 20,000 people have died by accidental overdose in Canada. The majority of lives lost were by people in their prime ages of their lives, 20 to 49 years old. Of course, these fatalities are a result of the failures of the Canadian government's drug policies. Yes, they have come a long way, but they are far from great, let alone perfect. Modern drug policies are based on prohibition, mainly forbidding an act or behavior by law where people face criminal penalties, including fines and imprisonment, for the contravention of that law. Canadian drug laws prohibit the possession, distribution, and of course production of drugs without proper authorization. Dr. Perry Kendall, a provincial health officer, states we need to recognize that it's not deviant or pathological for humans to desire to alter their consciousness with psychoactive substances. They've been doing it since prehistory, and it can be in a religious context, it can be in a social context, or it can be in the context of symptom management. Meaning, just prohibiting the use of narcotics isn't a step forward in the correct direction to limit substance use. In Canada, it's estimated that as little as 10% of illegal drugs are intercepted by law enforcement. Even prisons, an environment where people are sent for criminal activity, have drugs. This should implore us to find new ways to move forward. The system is clearly broken. Currently, there's a lot of controversy surrounding the usage of drugs today. One of the main concerns is how accessible drugs are to adolescents, mainly vaping. In Canada, you are not allowed to use or even purchase a vape in any form under the age of 18, and in some provinces under the age of 19. Despite this, a lot of the population under 18 have all sorts of drugs in their possession. The more harmful drugs such as heroin and cocaine are relatively harder to come by in adolescents. However, vapes, which contain nicotine, are relatively common. In a survey conducted in 2018 to 2019, it showed us that 34% of students in grades 7 to 12 had tried a vaping product in their lifetime, and 20% of them reported using them within the last 30 days. Specifically, 28% had tried a vape with nicotine in their lifetime, and 29% had tried a vape without nicotine. The survey also concluded that in the last 30 days prior, 18% of students have used a vape with nicotine and 11% have used a vape without nicotine. Most students who had tried a vaping product also tried a cigarette. 54% of all students thought it would be fairly easy or very easy to get a vape with nicotine if they wanted one, and 58% thought it would be easy to get a vape without nicotine if they wanted one. Comparing the nicotine versus non-nicotine vapes, they seem to not vary in percentage that much. This is concerning because drug usage in teens can cause worse long-term damage than to adults, as they're in their prime growing stages of their lives. The prime chemical in vapes is nicotine. Nicotine can alter teens' brain development and cause them to more or less be non-functioning members of society. Even if some vapes don't contain nicotine, the majority of them vary in the amount of nicotine percentage. This gets to the point where some vapes actually contain more nicotine than traditional cigarettes. It's a well-known fact that smoking is the leading cause of preventable disease and premature death, the most common preventable disease being lung cancer. Well, reports show that vaping can also cause lung cancer. Of course, the majority of parents would be concerned about their children vaping or even having access to a vape. Why risk getting addicted to nicotine and having long-term damage? There are also people who think that it is okay, mainly because they don't realize the damage that could be done, or they just don't value their lives. It might look cool and fun, but is it worth it? Different people will disagree with any solution proposed, so it's the law's responsibility to decide on something that reduces harm. Vaping is a lesson in irony, since the whole purpose of the vape was to reduce smokers, but instead, in a way, it created more. In the description, you can find a little assessment for you to do. Try it out and see how much knowledge you've gained from this. Of course, if you don't remember anything, you can always replay the video. Additionally, you can check out some resources I've had linked down below. I specifically recommend Street Pharm by Allison von Diepen. It's about a boy named Ty Johnson who is 17 years old, who's in a business that involves drugs. In case you're wondering who I am for some reason, I'm Sulaim Ali, more commonly known as Sai. I'm an 11th grade law student at Bloor Collegiate Institute. I currently live in Northern Etobicoke in Ontario. As you can probably tell by the format of the video, I have a hobby for art. Other than art, my hobbies would include video editing, photography, and the occasional gaming. Career-wise, I would like to become a neurologist. Originally, I was going to drop the law course since it had nothing to do with my career path, but after having so much fun learning about it, I decided to stay, and I'm glad I did.